The new rules after one big beautiful bill act quietly flipped the game. For most families, estate tax isn't the big threat anymore. The real wins now, keeping more after-tax money, sometimes $20,000 to $50,000 plus a year, securing the right step-ups in basis to erase capital gains, and protecting assets from life's curveballs. Today, I'm going to show you what changed and the new playbook that smart families are using right now to keep more, protect more, and sleep better at night. Before we dive in, just a quick note. I help families navigate estate planning strategies, but I'm not an attorney. This isn't legal advice. It's a roadmap you can use to have a smarter conversation with your estate planning lawyer. So what actually changed? OBBBA locked in a $15 million estate tax exemption per person, $30 million for couple, starting in 2026 and growing with inflation. For 99% of families, that takes federal estate taxes off the radar. But permanent only lasts until the next law, so flexibility still matters. The biggest shifts are income tax related. A higher standard deduction means fewer people itemize, so charitable giving often works better through a trust with charitable authority, or directly from IRAs. Itemizers face a 0.5% haircut on charitable deductions, and the SALT cap jumped to $40,000 through 2029, making where your trust is taxed more important than ever. Put it all together, and the real opportunity isn't in dodging estate taxes. It's in smarter income tax planning. And because tax laws don't sit still and change course every few years, the smartest plans build flexibility. And that brings us to the first opportunity in this new playbook. Preserve and create basis step up. If federal estate tax isn't your main issue anymore, chasing discounts or pushing assets out of your estate can backfire, because you could be throwing away a step up in basis that wipes out capital gains for your family. Picture this. You bought a rental property years ago for $300,000. Today it's worth $1.3 million. Nice growth, right? Before OBBBA, a lot of people were told, move assets out of your estate to dodge estate tax. But here's the catch. If that rental stays in your estate, your heirs may inherit it with a new basis at $1.3 million. If they sell it, they could owe little or no capital gains tax, sometimes a six-figure difference. Old strategies like family partnerships and valuation discounts might actually hurt you now if they reduce the fair market value that could have stepped up. It's time to revisit those moves. And here's something couples in common law states should know. Community property trusts. Alaska and Tennessee offer them, and with proper structuring, even non-residents may be able to use them. At first spouse's death, instead of just stepping up half the assets, the entire trust property can get a full basis reset. For those with appreciated assets, that double step-up can be a game changer. Here's the big takeaway. For many families today, it's not about moving assets out of the estate. It's about being intentional with what stays in. And ask your attorney about flexible tools like limited powers of appointment or trust protector provisions, so you can swing between estate inclusion and exclusion if laws change. Opportunity number 2, re-audit all trusts blocking step-ups. This is where a lot of families are quietly bleeding taxes without realizing it. Back in the mid-2000s and early 2010s, estate tax was the big villain, and many estate plans drafted in those years were built around avoiding it. Tools like credit shelter trusts and bypass trusts were lifesavers at the time. But today, those same structures can trap low basis assets and cost your heirs more in capital gains tax than estate tax ever would have. Here is how it often plays out. I've seen families, great savers, meticulous planners, sell appreciated stock that's been sitting in an old bypass trust. The result? Tens of thousands in capital gains taxes that could have been erased with a step-up. That's money gone forever. The fix isn't to toss the trust, it's to tune it. Talk to your estate planning attorney about whether it makes sense to add flexibility, update provisions, or even give a trust protector authority to adapt. Don't let an old plan written for yesterday's laws rub your family under today's rules. Now, let's talk about opportunity number 3, downstream income planning. Think of this as shifting the tax hit without giving up control. Here's something most families don't realize. You don't have to hand over the vacation home to save on taxes. You can shift where the income is taxed without losing control of the asset. Say your family has $150,000 of passive income from rentals and investments. On your return, that income might push you into higher phase-outs. higher Medicare premiums, even more Social Security tax. But structured correctly, a non-grantor trust in the right jurisdiction can pick up some of that income. That can trim the overall tax bill, sometimes by 5 figures a year, while you still keep the long-term estate goals intact. Think of it like rerouting traffic around a jam. You are not changing the road, just redirecting cars to a smoother path. And for families with kids in their 30s or 40s who live in lower tax states, there is something called a beneficiary defective trust. It basically lets the child be treated as the income tax owner of the trust income, without actually giving them the asset itself. Done right, that shifts the tax burden to someone in a lower bracket, keeps your estate plan intact, and preserves future step-ups. That's what I call smart tax engineering. Less tax drain now, better after-tax wealth later. And the best part, you stay in control, while your advisor, CPA, and attorney coordinate the details. Opportunity number 4 is one of my favorites. Charitable giving that actually cuts taxes. Many people give $10,000, $20,000 a year from the heart, but the tax benefit often gets lost. Here's the tweak. If a trust has charitable authority built in and it receives that income, it can sometimes deduct gifts of gross income to charity, even when you personally would not get a deduction. That way, you keep your standard deduction and still cut taxes. But heads up, this has to be written into the trust from the start. You can't just bolt it on later. Let's say you give $20,000 yearly to charity. Run it through a trust instead of personally, and the trust may deduct it fully, offset income, and could save $7,000 plus in taxes annually. You keep your full standard deduction, and your giving packs a bigger punch. If you are 70 and a half or older, qualified charitable distributions from IRAs are another clean tool. They satisfy required distributions and flow tax-free to the charity. The key here is integration. Charitable planning belongs inside the estate plan, working hand in hand with everything else. Because when it's aligned, the tax savings finally show up where you can see them. Next up, opportunity 5, protection first. Let's be blunt. If estate tax isn't your family's biggest threat anymore, lawsuits, creditors, and family drama probably are. I once knew someone who said, "We are not litigious people." Neither were the folks who rear-ended them at a stoplight. Accidents happen. In some states, simply titling your home as tenancy by the entirety gives married couples powerful protection from creditors. Combine that with a plan for the survivor, say funneling assets into a protective trust at the first death. That way, the surviving spouse is cared for, and the kid's inheritance isn't exposed to a remarriage, creditors, or poor decisions. And don't overlook modern protection tools. SLATs, spousal lifetime access trusts, SPATs, spousal power of appointment trusts, even hybrid domestic asset protection trusts can all layer in flexibility. They let couples protect assets, preserve access, and still keep options open if loss swings back. That's the kind of planning that preserves both lifestyle and legacy. Opportunity number 6, business and capital gain tools. Not every family needs this, but if you own a business or have concentrated investments, this could be especially important. Qualified opportunity zones still let you defer capital gains, and if you hold for 10 years, appreciation in the zone can be tax-free. It's not for everyone, but for the right investor, it's powerful. Qualified small business stock can allow you to exclude large amounts of gain when you sell, if you meet the requirements. It's one of the few remaining 0% capital gains opportunities in the code. And here's one people often overlook. Old buy-sell agreements. Many were written to keep values low for estate tax planning. But if estate tax isn't your issue anymore, those artificially low values may just be setting your heirs up for unnecessary capital gains. Sometimes resetting to fair market value is the smarter long-term move. These tools aren't for everyone, but they can save real dollars if they fit your situation. Here's opportunity number 7. Beware the basis mirage. Not every asset gets that magic reset. IRAs and other retirement accounts are different. They are considered income in respect of a decedent. That means they don't step up. If giving to charity is in your plan, it often makes sense to align IRAs with charitable goals. Let the charity inherit the IRA dollars, they pay no income tax. Then let the kids inherit the step-up assets, like the home brokerage account. Same generosity, way better after-tax outcome. And finally, opportunity number 8, build for reversals without rewriting your life. If there is one certainty about tax law, it's this: it changes. We can't forecast perfectly, but we can prepare. And the smartest way is to bake flexibility in your documents now. Think like trust protector powers, limited powers of appointment, and thoughtful trustee succession. That way, you don't need a crystal ball. You just need a plan that lets you toggle between estate inclusion for step-ups or exclusion if estate taxes ever come roaring back. Flexibility is what keeps you in control without rewriting your entire plan every election cycle. Before we wrap up, let me flag a few traps I see families stumble into. All bypass trusts. Once useful, now they can block step-ups and cost six figures. IRAs don't step up. Don't assume they will. State estate taxes. Federal law may not apply, but some states still bite. Phase-outs and caps. SALT, QBI, charitable limits can quietly erase your savings. Awareness here can save your heirs thousands. Alright, let's lock it in now. Your power moves. Preserve and create basis step-ups. Don't waste them chasing outdated discount strategies. Re-audit all trusts. They may be blocking flexibility and costing you six figures. Use downstream income planning to shift taxes, not ownership. Align charitable giving so it actually reduces taxes through proper vehicles. Put protection first. Update titles, create spousal trusts, and use modern tools like sleds. Explore business and capital gain tools if they fit your situation. Remember, IRAs don't step up. Align them with charitable goals instead. Build flexibility so your plan can adapt when laws change. This is how families with 1.5 to 5 million plus protect what matters, cut lifetime taxes, and keep the peace. But before making changes, sit down with your advisor and estate planning lawyer. One wrong move can create headaches for your family down the road. You've seen how these new rules change the playbook. Next, check this video where I'll show you the most common basis and beneficiary mistakes, how to avoid them so more of your money stays with the people and causes you love.